Good morning, Barb Teachblade Reynolds here, blog author for Paralegal Brain blog. I'd like to talk to you a couple of minutes regarding the difference between legal remedies and equitable remedies. It's a damage issue that is sought in court. And say, for instance, if someone sued for a breach of contract, they're asking for a legal remedy of money, which is what a legal remedy is. It provides the plaintiff, once the plaintiff wins the case, it provides the plaintiff with money damages, as opposed to equitable remedies, which provide some type of do the right thing remedy, because money damages in that case will not suffice. If you are suing for an equitable remedy, you must state within the complaint itself that there is no adequate remedy at law. In other words, money damages will not suffice. It's not adequate. It's inadequate, and therefore you're suing in equity to get one of four results: either specific performance by which the court will order the defendant to perform, or rescission of an agreement, or restitution, or reformation of a contract. I read a case yesterday and wanted to talk about that case within the context of a specific performance equitable remedy. But suffice it to say, a rescission occurs, say for instance, if you purchase a car, and days later the car dealer decides that he or she wants to up the ante. You're not satisfied with that, and you say to the car dealer, look, give me back my trade-in, I'll give you back your new car, we can walk away from each other, bye-bye, that's it. So it returns the parties to the original position before they ever contracted with each other. Rescission involves a case where if you were a defendant, and somehow out of that deal you received unjust enrichment, which was to the detriment of the plaintiff, that would be a cause of action for restitution. Reformation involves a contract that had been agreed upon, and sometime later one of the parties changed the terms of the contract unbeknownst to the other party. Once the other party found out about the changes in the contract, he or she has sued for reformation of the contract. They still want the benefit of the bargain, but they want the contract reformed back to when the original terms were agreed to, when there was a meeting of the minds at that particular time. Specific performance is an interesting equitable concept that arose in the case of the Baby M case. Some of you may not recall that, but it was about 25 years ago when the issue of surrogate parenting and the Baby M case was a hot button issue. The birth mother, Patricia, was the person that owned the eggs, and after the gestation period, she gave birth to the baby. She decided, oh, I love my baby and I do not want to give my baby up. So the couple that had contracted to obtain the child, once the child was born, in exchange for taking care of the maternity expenses and her downtime and incapacity as a result of the pregnancy, Patricia decides at the last minute that she does not want to give the baby up. So enters litigation. The couples decide they're going to sue for breach of contract. Well, guess what? That contract was void because it wasn't voidable, capable of being voided. It was void before the ink even dried, because the underlying act, which was to give over the baby in exchange for money, the court found that that was tantamount to baby selling. And the court could not countenance an illegal act. Therefore, the contract upon which the illegal act was bottomed was too illegal. Therefore, there was no breach of contract. So what the court did, it decided they're going to give the baby to the couple anyway, because it was the right thing to do. And that's what equitable remedies do. They're the do the right kind of thing results and remedies that people seek. And the court, in fact, in its wisdom, gave the baby to the couple. Enters a new case that the lawmakers are trying to decide right now, and that is whether or not women should be allowed to carry a child to term and be compensated for it. But now there's a new twist. They're no longer called surrogate mothers. They're called gestational carriers, because they do not own the eggs. The eggs are transferred into the birthing mother, who then carries the baby to term, and those eggs are impregnated by a male sperm donor, presumably the father. So if the birth mother decides at the last minute she wants to keep the child, there may be an issue because she doesn't own the eggs, therefore that is not her child. And conceivably, she could come up on a criminal charge for grand theft because she did receive money as well as possible kidnapping charges. So that was a new twist to obviate this prior 25-year-old condition where the parent, the birth mother, decides at the 11th hour, no, I don't want to give my baby up. Another interesting provision that the lawmakers are considering in the state of New Jersey, by the way, where the Baby M case originated, they're also considering this concept called uncapped a money award to the birthing mother. And that's interesting because it's silent as to the issue of how much. Presumably, it's for the maternity costs and for the cost of the mother's downtime and incapacity during the period of the pregnancy. Well, if it's uncapped and silent as to that, that says volumes, really. Sometimes what a case doesn't say speaks volumes louder than what the case actually does say. So it'll be interesting to watch to see what the court decides in terms of this so-called uncapped award that would be given to the birth mother, which conceivably could be millions. So it'll be interesting to watch, and you can, I'll post anything that I hear regarding that on Paralegal Brain Blog, which I hope you do read every day because I do post daily. Take care. Have a great day. Talk to you soon.